Good day, everyone. My name is Jade Downing from BSHM 3A, and I'm going to discuss about the law on partnership and corporation in Chapter 4. So first, let's discuss on the learning objectives. So first is differentiate the various kinds of partnerships and corporations and the responsibilities of partners and incorporators. Then, identify the requirements in the information and dissolution of partnerships and corporation. Then, the topic outline is the law on partnership, classification on partnerships, forms of partnership, dissolution and winding up of a partnership, order of liquidation for a general partnership, order of liquidation for a limited partnership, law on corporation, kinds of corporation, advantages or disadvantages of corporate organization, dissolutions of corporation, government requirements in doing business as a partnership or corporation, then the code. Law on partnership. Article 1767. By the contract of partnership, two or more persons bind themselves to contribute money, property, or the industry to a common fund with the intention of dividing the profits among themselves. The discussion of the law. A partnership is an association of two or more persons to carry on as co-owners of a business for profit. The definition of a partnership does not include religious associations, conjugal partnerships, and other of a similar nature because a partnership as defined by law refers only to associations, the purpose of which is obtain profits to be distributed among the partners. A partnership is a legal relationship where two or more individuals collaborate as co-owners to operate a business with the primary goal of earning profits. This definition emphasizes the profit-driven nature of the partnership, meaning it is focused on financial gains shared among its partners. Non-profit organizations like religious groups and personal arrangements like conjugal partnerships are excluded because they do not aim to generate and distribute profits. Partnerships are distinct legal entities that revolve around mutual agreement and contributions of partners to achieve common business goals. The law specifically applies to the term partnership to profit-oriented associations, separating them from other forms of collaboration with non-commercial purposes. So let's talk about goals. The advantages of forming a partnership. Number 1, easy to form. Partnerships are straightforward to establish with minimal legal formalities compared to corporations. Number 2, improve growth possibilities. Combining resources, skills, and expertise of partners enhances the potential for business expansion. Number 3, freedom from bureaucracy. Partners can make decisions quickly without being hindered by excessive regulations or procedures. The disadvantages of forming a partnership. The number 1, instability. Partnerships may dissolve due to disagreements, withdrawal, or the death of a partner. The number 2, difficulty in obtaining large sums of capital. Unlike corporations, partnerships have limited access to substantial funding sources. Number 3, firm is tied to the acts of and judgment of one partner as agent. A single partner's decisions or mistakes can bind or harm the entire partnership. Number 4, difficulty in severing partnership ties. Ending a partnership is often complex and may lead to disputes among the partners. Classification of partnerships. According to subject matter, universal partnership, all partners contribute all their properties. Then this type is rarely used today. Particular partnership, formed for a specific purpose, profession, or business activity. According to liability, general partnership, all partners have limited personal liability for the partnership's debts. Limited partnership includes both general and limited partners. Limited partners are liable only up to their capital contribution. According to duration, partnership for a fixed term established to last for a set period or until a specific object is achieved. Let's talk about the forms of partnership. So a partnership can be in any form, even if not recorded at the Office of the Securities and Exchange Commission, except number one, when it is stipulated. Then number two, when immovable property or real rights are contributed, in which case there must be public instrument to which is attached an inventory of the immovable properties and signed by the parties. Otherwise, the partnership is void. Number three, in case of limited partnership, the parties must sign and swear to their certificate, which shall state, among others, the name of the partnership, adding the word limited and the character of the business. Then file for record and certificate in the Office of the Securities and Exchange Commission. Failure to comply with the foregoing formal requirement will only make partnership a general partnership. Dissolution and winding up of a partnership. Article 1830, causes of dissolution without violation of the agreement, termination of a definite term or undertaking. The partnership ends naturally when the agreed period or specific business activity is completed. Express will of a partner. Any partner may dissolve the partnership provided it is done in good faith when there is no fixed term or specific undertaking. Mutual agreement of all partners. The partnership can be dissolved by anonymous consent of all partners, provided their interests have not been transferred or charged for personal debts. Expulsion of a partners. If allowed by the partnership agreement, a partner may be expelled in good faith or for valid business reasons. Contravention of agreement, a partner may dissolve the partnerships at any time, even if it goes against the partnership agreement when other provisions do not apply. Illegality. The partnership is dissolved if an event makes it illegal to continue the business for partners to operate as a partnership. Loss of contributed property. The partnership ends if a specific item a partner promised to contribute is lost before delivery, or if the item is destroyed when only its use was transferred. Then, however, the partnership continues if the item was already owned by the partnership. Death of a partner. The partnership is dissolved upon the death of any partner. Insolvency. The partnership is dissolved if any partner or the partnership itself become insolvent. Then in civil interdiction, a partner's loss of legal capacity due to civil interdiction can lead to dissolution. Decree of court. Dissolution may occur by court order as outlined in Article 1831. Court order dissolution in Article 1831. Insanity or unsound mind. If a partner is declared insane or mentally unfit through a judicial process, incapacity to perform, a partner become incapable of fulfilling their obligations under the partnership agreement. Prejudicial conduct. A partner engaged in behavior that negatively affects the partnership's ability to carry on its business. Breach of partnership agreement. If a partner persistently violates the partnership agreement or behaves in a way that makes it impractical to continue the business with them, operating at a loss, dissolution may be ordered if the partnership can only sustain continued losses. Equitable circumstances. Any other situation that makes dissolution fair and just under the circumstances. Dissolution on purchases application. Articles 1813 or 1814. After the specific term or undertaking ends, a purchaser of a partner's interest can apply for dissolution once the partnership's agreed term or project concludes. Then partnership at will. If the partnership was at will, the purchaser may seek dissolution at any time after the interest was assigned or charged. Order of liquidation for a general partnership. Article 1939, in settling accounts between the partners after dissolution, the following rules shall be observed, subject to any agreement to the contrary. The liabilities of the partnership shall rank in order of payment as follows. Then first, those owing to creditors other than the partners. Second, those owing to partners other than for capital and profit. Third, those owing to partners in respect of capital. And fourth, those owing to partners in respect of profits. Take note that the liquidation process under the above provision applies only to a general partnership. There is a different process for liquidation of a limited partnership. Order of liquidation for a limited partnership. Article 1863. In settling accounts after dissolution, the liabilities of the partnership shall be entitled to payment in the following order. First is to those two creditors, in the order or of priority as provided by the law, except those two limited partners on account of their contributions, and two general partners. Second, those two limited partners in respect to their share of the profits and the other compensation by the way of income on their contributions. Third, those two limited partners in respect to the capital of their contributions. Fourth, those two general partners other than for capital contribution. Fifth, those two general partners in respect to profit. And sixth, those two general partners in respect to capital. The above provision expressly provides for priority in the distribution of assets after dissolution of a limited partnership. Law on corporation. Section 2 is corporation defined. A corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. In the Philippines, the law which governs the creation of private corporations is Batas Pambansa LG 68, known as the Corporation Code of the Philippines. The powers of all corporations are limited to those mentioned in their charters or in the general acts under which they are created. A corporation is a legal entity created by law, separate from its owners, with rights and powers granted by law. It is considered an artificial being, meaning it exists only through legal recognition and continue to exist regardless changes in the ownership or management. In the Philippines, the creation and governance of a private corporations are regulated by Batas Pambansa BLG 68, also known as the Corporation Code of the Philippines. This code outlines the rules for forming, operating, and dissolving corporations. The powers of a corporation are restricted to those explicitly stated in its charter or under general laws. It cannot act beyond these specific powers, ensuring that its operation align with its legally defined purpose and scope. Kinds of corporation. First, stock corporation. A corporation that issues shares of stock to its members, allowing them to own a part of the corporation. Shareholders can receive dividends and have voting rights. Second is non-stock corporation. A corporation that does not issue share of stocks. It is often formed for non-profit purposes such as charities or educational institutions. Next is the corporation de jure. A corporation that has been properly incorporated according to the law, with all legal requirements met. It is a fully recognized and legitimate corporation. Next, de facto corporation. A corporation that operates as if it were legally formed but has not fully complied with all legal requirements. It has some protection and rights but may not be recognized as fully legitimate in certain cases. Next is public corporation. A corporation created by the government for public purposes, such as a state-run enterprise or a government-owned corporation. Next is the private corporation, a corporation formed by private individuals or entities for business purposes. It is not owned or operated by the government and is typically focused on profit making. Advantages of corporate organization. Advantages of corporate organization: strong, separate judicial personality. A corporation is a distinct legal entity separate from its owners, allowing it to enter contracts, sue, or be sued in its name. Limited liability to investors. Shareholders' personal assets are protected and they are only liable for the amount they invested in the company. Free transferable of units of ownership. Shares of stock can be easily bought or sold, offering liquidity and flexibility for investors. Centralized management through the board of directors. A board of directors makes major decisions, providing organized and efficient leadership. Professionalism. Corporations often attract skilled professionals to manage and operate, enhancing business competence. Easier to sell amounts of stocks to raise capital. Corporations can raise funds by issuing shares, making it easier to obtain capital for growth and expansions. Disadvantages of corporate organizations. Extensive government regulation. Corporations must comply with numerous laws and regulations, which can be time-consuming and costly. Double taxations. Corporations are taxed on their income, and shareholders are taxed again on dividends they receive, leading to double taxation. Activities are limited by character and various laws. Corporations must operate within the scope of their charter and relevant laws, restricting their flexibility in some areas. Dissolution of a corporation. Voluntary dissolution. The corporation chooses to dissolve itself by submitting the necessary documents to the Securities and Exchange Commission. Involuntary dissolution. The SEC dissolves the corporation upon a verified complaint after notice and hearing, and for reasons allowed by law. Expiration of corporate term. A corporation may be dissolved when its specified term, as stated in the Articles of Incorporation, expires. Shortening of corporate term. Under Section 120 of the Corporation Code, a corporation may dissolve earlier than initially planned if the term is shortened. Failure to organize and start business. If a corporation does not begin its business operations within 2 years of receiving its certificate of incorporation, it may be dissolved. Legislative dissolution. A corporation may be dissolved by an act of legislation, such as a law specifically repealing its charter. Government requirement in doing business as a partnership or corporation. For registration of business under the Bureau of Internal Revenue, to acquire a tax identification number, to business permit from the local government unit concerned, certificate of registration with the DTI, articles of partnership, articles of incorporation, and bylaws, 500 pesos annual registration fee. For registration at the Social Security system, to acquire an SSS number and PhilHealth number, business permit from the local government unit concerned, certificate of registration with the DTI, articles of partnership, articles of incorporation, and bylaws. Government requirement in doing business as a partnership or corporation. For registration of business name under DTI. For partnership, articles of partnership with a birth certificate of all the partners with their 2x2 picture. For the corporation, articles incorporation bylaws, certificate of incorporation, birth certificates of all the incorporators with their 2x2 picture. For acquiring a business permit with the city or municipal mayor, barangay police clearance, barangay or police clearance, certificate of registration with the DTI, articles of partnership, articles of incorporation, and bylaws, then payment of fees. So that's all for my topic in this chapter 4. So let's end this report or topic with a quote, "Believe you can and you're halfway there" by Theodore Roosevelt. So this is a powerful quote by Theodore Roosevelt. It emphasized the importance of self-belief. Then once you have the confidence in yourself, you're already on your way to achieving your goals. It's all about taking that first step with that right mindset. So thank you everyone. Once again, I am Jade Claire G. Downing from BSHM 3A, and see you again to the next chapter.